marriage-based green cards, faster approvals, and new USCIS rules. In recent months, the marriage-based green card process has undergone noticeable changes in how applications are handled and how quickly they move through the system. For applicants with strong, well-documented cases, the shift has been largely positive. Processing times have significantly improved in many regions, allowing some applicants to move from filing to approval in as little as 3 months. While this speed might sound almost too good to be true, it reflects a series of policy changes within U.S. Citizenship and Immigration Services, USCIS, aimed at clearing long-standing backlogs and rewarding clean, complete applications. Applicants who have no criminal background, no past immigration violations, and no fraud or misrepresentation issues are seeing the most benefit. These streamlined approvals have transformed what was once a slow, uncertain process into a much faster journey toward permanent residence. However, the new pace comes with a caveat. While strong cases move fast, weak or incomplete ones are facing higher risks than before. The rise in denial referrals. One of the more concerning changes is the government's handling of denied applications. Previously, a denial often meant applicants could simply reapply or correct errors later. Now, a growing number of denied marriage-based applications are being automatically referred to immigration court for removal proceedings. This policy shift has created hesitation among many who would otherwise be eligible to apply. For individuals with complications such as old immigration violations, criminal records, or prior fraud findings, the risk of being placed in deportation proceedings is now very real. The decision to apply for adjustment of status requires a careful, case-by-case evaluation. Families and attorneys must weigh the potential benefits of applying against the possibility of triggering a removal case. The calculation has become much more strategic. Remaining undocumented also carries its own dangers, so the question is not simply whether to apply, but when and under what conditions it's safest to do so. Balancing risks and opportunities. This dual outcome, either rapid approval or placement in removal proceedings, has redefined what it means to apply for a marriage-based green card in today's environment. The same speed that delivers approvals in record time can also deliver denials just as quickly. Applicants who lack legal status and have risk factors must therefore think ahead. For example, someone who entered the U.S. unlawfully but later married a U.S. citizen might qualify for adjustment but require a waiver for past violations. If the waiver is denied, the applicant could immediately be placed into immigration court. The consequence is not just financial stress, but emotional strain for entire families. Still, the reverse is also true. Those who prepare thoroughly, provide consistent evidence, and meet all eligibility criteria are seeing approvals faster than at any other time in the last decade. It is a system that rewards strength but punishes uncertainty. Why processing times are dropping? Many have wondered why these processing times have suddenly improved. A closer look suggests a combination of administrative efficiency and political motivation. USCIS appears to be clearing backlogs through a faster triage approach, pushing strong cases through quickly while routing questionable ones toward enforcement. In areas like New York, Chicago, and Los Angeles, immigration officers are now completing marriage-based adjustment cases within 90 days of filing. This represents a massive reduction from the traditional 10 to 14 months. The shorter timeline benefits U.S. citizens and lawful permanent residents seeking to reunite their families, but also helps USCIS demonstrate measurable productivity. However, this efficiency doesn't mean the process is lenient. Officers are scrutinizing documentation with equal or greater intensity. The new environment demands precision, transparency, and strong evidence of a bona fide marriage. Interpreter requirements, a significant adjustment. Another major procedural change affects applicants whose English proficiency is limited. In the past, USCIS routinely provided telephonic interpreters during interviews through contracted language services. That practice has now ended. Applicants are required to bring their own interpreters to marriage-based interviews. This change might seem small, but has serious implications. Applicants who arrive without an interpreter risk having their interview rescheduled, or worse, denied for failure to comply with interview requirements. While some local offices are granting short grace periods, others are enforcing the rule strictly. The key takeaway is clear. Every applicant whose interview is not conducted in English must now plan in advance. Hiring a qualified interpreter is no longer optional. It's essential for the case to proceed smoothly. Preparing updated evidence before the interview. A procedural update that has quietly improved efficiency involves how applicants submit updated evidence. USCIS officers are now encouraging applicants to upload new documents, such as recent bank statements, joint insurance, or travel photos, through the USCIS portal several days before the interview. This step helps officers review the latest evidence in advance and reduces time spent scanning and labeling physical paperwork during the interview. While this is not a mandatory requirement, it is a recommended best practice. Applicants should still bring physical copies of all documents, including originals like marriage and birth certificates, passports, and prior immigration records. By submitting updated materials early, applicants can help ensure that their interviews focus on substance rather than administrative delays. This proactive approach often leads to a smoother experience and, in some cases, quicker decisions. Increased scrutiny and policy motivation. The faster approvals and harsher denials both seem to stem from the same underlying objective, creating a more decisive immigration system. Some experts believe this shift is part of a broader federal strategy to demonstrate strictness on immigration enforcement while improving service delivery for those who comply with the law. It's a high-stakes balance, rewarding well-prepared applicants while swiftly removing those who do not qualify. The result is a system that operates at two extremes: speed for some, scrutiny for others. Families need to understand that the same policy that brings relief to one applicant could bring removal proceedings to another. The reality for applicants nationwide. Applicants in the New York area are not the only ones seeing changes. Reports from Texas, California, and Florida indicate similar patterns: accelerated approvals for strong cases and increased referrals for denials. The variance between offices remains, but the national trend is unmistakable: faster adjudication across the board, paired with reduced tolerance for error. Applicants with existing visas such as H-1B may experience some protection if their adjustment of status application is denied, allowing them to remain in the U.S. under their current visa terms. However, those without lawful status face much greater risk, making professional legal guidance more important than ever. The importance of legal strategy. This evolving environment highlights the importance of preparation and legal strategy. Every document, timeline, and answer must align perfectly to reflect a genuine marriage and lawful eligibility. Applicants should avoid assumptions that a faster process equals easier approval. In reality, the opposite is true. The margin for error has narrowed. Legal professionals now spend more time than ever preparing clients for interviews, reviewing documentation, and anticipating potential red flags. The stronger the preparation, the better the chances of benefiting from the current policy rather than suffering its consequences. It's also worth noting that these rapid shifts may be part of a longer-term administrative test. USCIS appears to be evaluating how technology, streamlined review systems, and applicant self-service portals can reduce workloads. If these pilot efforts prove sustainable, the agency could expand similar fast-track processing to other categories, such as employment-based or family reunification visas. For now, marriage-based green cards are the proving ground for this new hybrid approach to immigration efficiency and enforcement. Final thoughts. The marriage-based adjustment process is evolving quickly. For eligible applicants with clean records, the opportunity to gain permanent residence faster than ever is real. But for those with unresolved immigration or criminal issues, the risk of denial and referral to immigration court has never been higher. Applicants should approach this new environment with caution, strategy, and full understanding of their rights. Preparation, accuracy, and professional guidance can make all the difference between a fast approval and a devastating denial. That's all for today. Stay tuned for more updates and insights right here on Visa Intel USA. Don't forget to subscribe and hit the notification bell so you never miss a critical immigration update.